So yeah, his name is Golightly. It's like Breakfast with Tiffany's.
Really?
Yeah.
Which one was he?
Oh, no, that's her last name.
Oh, okay.
Holly Golightly.
That was her name?
Yeah, her last name.
Can't remember the actress's name.
Audrey Hepburn? Yeah. Have you seen that movie?
Yes.
It's a good movie, huh?
Yeah, excellent movie. Very long time ago. Excellent.
Yeah, the galaxy far away, right? And that boo was under an attack. Right?
I don't really remember a whole lot of it.
Well, I mean,
Sure.
where are my class notes?
I'll find it. So you better not be failing. Every fourth person. 1, 2, 3, 4. No. This was it.
Failing what? The bar? Every fourth person failing the bar?
We had a 70% bar.
Well, I'm taking the February bar, so I'm not included in it.
What are we doing in February?
I think we used to do better.
Did we do? Well,
And it starts on my birthday, so.
that's the
I'm gonna pass. That will be the next thing.
Highlighting, right? I love to like highlight books, you know what I mean?
I want everyone in this room to pass the bar exam. I want everyone in the room to pass the bar
Victory.
exam. But based on the results we had today, 1, 2, 3, 4, 1, 2, 3, 4, 1, 2, 3, 4. Every fourth person's failing the bar exam. So we don't want that, okay? We don't want that to happen. 1, 2, 3, 4. I don't want that to be you, but I want to point at people. So, but that's not. It's not. People ask me, what do I think about the results? Disappointing. Catastrophic? No, I don't think so. I think some of my colleagues would think it's catastrophic, 74%, 73.96, but it's counted. But I think it's disappointing. We would surely like to be above the state average. The state average is, what, 76.6. Like to be above the state average, like to be better than 6 out of 9 law schools. Come on, UNT, come on. We want to be 6 out of 10. But that was a joke. That was a UNT joke. Yeah. I mean, if UNT comes in and has, like, #1 bar passer rate the first time out, I don't know, I'll probably just hang it up. I think it's going to be a long time before that happens. But it is disappointing. So please, 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 my new slogan, some of you heard, a couple of you are in my day class and heard it already. My new slogan is, take it seriously or take it again. Okay? So take that bar exam seriously or take it. Would you like that, Ms. Penny? What do you think?
I did like
Is that a pretty
that.
good one? Okay. Take it seriously or take it again. Right? So I'm sure you heard that. So you're not, I'm pointing to people, you're not going to be the ones who fail the bar. It's like, did you ever see The Office?
Yeah.
The Office? I don't know if you remember the English version of The Office or not, the original one with, what's the guy's name? Rick Gervais, yes, he's so funny. And there was just one, there was a rumor that they were going to be downsized, and he said, oh, come on, it's not true. And even if they're going to be downsized, you're not going to be fired. You're not going to be fired. You're not going to be fired. I want everyone here to pass the bar exam. Everyone pass the bar exam. But you got to take it seriously. And the rumor is, there's always, like every other someone on the law review fails. So the rumor is that someone on the law review failed. I don't know. I don't want to know. I'm not going to look at any of you law review people and ask you. But just so, but so we don't want that to happen. We don't want that. And one of my colleagues said, and I don't know how he knows, but he says that the person who was number, however many we had graduate, 150, 200, 150 or 200, the last person in the class passed. So that can happen. Law review people can fail, and people who haven't done well in law school can pass. But just, you got to take it seriously. Please, please, please do take it seriously. Remember, one of the ways that, and this is so, we talked about this, U.S. News rankings, and this is so circuitous, but one of the ways that our school is judged, rightly or wrongly, is by the U.S. News rankings. And one of the factors in the U.S. News rankings, and a big factor, and it's something we have to report to the ABA, is how many of our students are employed 10 months after graduation? And that is, how many are employed 10 months after graduation in basically JD required and JD advantage jobs? For the most part, those are law jobs which require you to pass a bar exam. If we have a 74% bar passage rate, 26% of those people won't be employed in those kinds of jobs for the most part. So we're starting. If we have 80 or 90% of that 74% employed, you do the math. That's only 50 or 60% of our people employed in JD and JD Advantage, because you can't be employed in those kinds of jobs for the most part if you don't pass the bar. So that hurts you, and it also hurts the reputation of the school. And when it hurts the reputation of the school, it devalues the value of everyone's degree. So please, please, please. I know it's an A&M degree, and I know many people think that that's a lot more valuable than the Texas Wesleyan degree was. It probably is. Certainly name recognition alone, but please take that bar seriously. And I'm not going to ask. Now I would say, and how many of you are taking the bar in February or next May? Next July. You don't have to raise your hands. I know a lot of you are, so please, please, please. I know you'll take it seriously. Some of you I know and I know are good, hardworking students, so do take it seriously. I know you will. You don't think you'll?
No, I mean, just close my mind. We will take it seriously.
I know.
Over $100,000.
I know. You spent $100,000 to come to school, and you would think you would take it seriously because you want to get out and get that job, and you don't have to take it again and postpone, put your life on hold, or take it a second or third or fourth time. Usually people have to take it more than once or even twice. But yeah, and I've seen people. I know I've seen people pass the third and fourth time, but why spend 2 years of your life doing that? I know one person who passed it on his fourth time out and just got disbarred. But that's not a graduate of A&M. That's a graduate of Texas Wesleyan, and he graduated a few years ago. And that was one of the most satisfying disbarments I've ever seen. But I love 99.9% of my students. This guy was the 0.01% that I didn't like. And if you ask other professors, he wouldn't like this guy either. So now I can't say what it is, right? They wouldn't like this guy. But he didn't take it seriously the first time. He didn't take bar practice seriously, and he got in trouble with the state bar and got disbarred about a year ago or so. Anyway, don't let that happen to you. Disbarment, of course, don't let that happen to you. But pass the bar the first time out, please, please, please. What's our motto? Take it seriously.
Take it again.
And some of you actually asked me. All right, I'm going to. Well, since time hasn't ticked away, which is really good. Oh, I'm keeping track. I'm keeping track too. Yeah, this is, I don't know, that's across the international date line or something. Since time hasn't ticked away, time's ticked away enough. That's probably all I want to say about the bar exam. I was going to say something else. Do take it seriously. And here goes. Let's start this around. I appreciate that. The pop quiz for tonight. You all got an email from me about where we're going to go next week, right? Where I want you to go next week. The pop quiz for tonight is this. We were talking about latent ambiguities and patent ambiguities. We're going to start on page 210 of the casebook about to what extent can we admit extrinsic evidence when there's no ambiguity in the will. The will is clear, but maybe it's the product of a mistake. So here goes. For example, try this situation. Suppose testator's will says his house to his son and his ranch to his daughter. No ambiguity about that. He has one son, he has one daughter, he has one house, he has one home. Right? Clear? But the attorney made a mistake. The attorney's notes would show that what testator really wanted was the ranch to go to his son and the house to go to his daughter. It was a mistake. Testator's dead. Can we admit extrinsic evidence to show that what was written in the will was the product of a mistake? Can we do that? May the attorney's testimony or his notes be admitted to correct that mistake? I'll look at that clock. No, I'll look at my watch. Take 30 seconds and answer that. One sentence. Yes, no, why? Based on what you read beginning on page 210. Yes, no, why? Okay, that's 45 seconds. What do you think? Yes, no, why? Does anyone know what the traditional common law rule in Texas was, and now to what extent has it been modified by statute? What do you think? Who wants to take it? The traditional common law rule. What's the extrinsic evidence is not admissible. Extrinsic evidence is the plain meaning rule. Plain meaning rule, and that is extrinsic evidence is not admissible to vary the plain meaning of the terms of the will. We admit extrinsic evidence to clear up an ambiguity, latent or patent, to show there is an ambiguity in the case of a latent ambiguity, or to correct a latent or patent ambiguity. We don't admit extrinsic evidence to vary the plain meaning of the will. Plain meaning when the will is not ambiguous, even if the will's language was the product of a mistake. This guy is exactly right. That's the common law rule. And until this year, September 1 of this year, Texas followed the common law rule. Now, do you know to what extent we've modified the common law rule? Well, certainly it's always been admissible to explain ambiguity, but what about the plain meaning? The will is a product of a mistake, but it's not ambiguous. Traditionally, the common law rule is plain meaning rule, extrinsic evidence is not admissible. Not admissible. Vary the plain meaning of the will. How has that changed, if at all? No, yeah, okay, that's all right, okay. It's all right. Who knows? Okay, no. Oh, why am I going down this row? Those people are in call and calling back, all right? Anyone back there or elsewhere? No. We got all the time in the world because it's still only 2:33, 2:32, 2:31.
I just want to take a stab. If it's if the words have a well-established meaning, then you're not allowed to have extrinsic input.
If the words have a well-established, and you're drawing that based on the case that you read tonight. But there's been a statutory interpretation, a statute that's, you're talking about the Gilkey case as opposed to the San Antonio Area Foundation versus Lang case, right? We'll get to those in a minute, okay? The statute was amended. Look at section of the Estate Code 255.451. And look, if you will, at subsection A, and see how the plain meaning rule has been varied, if at all. Don't look at the cases yet, because this statute may overturn those cases. San Antonio Area Foundation versus Lang. Well, we'll get to that. Look at subsection A. Look at 3, particularly look at A3. So, what do you think?
If they determine it's the Scribner's error, they can overturn it.
It's a Scribner's error. And what's the Scribner's error? Who's the Scribner? Well, it's the person who drafted the will, right? It presumably would be an attorney. could the testator be his or her own scrivener if it was a homemade will, for example? I think the answer is yes. I don't know the answer to that yet. This is a brand new statute. I suspect the answer to that is yes. So, if they can show by 255, 451 says ... a court may order the terms of the will be modified or reformed ... if, so that's, I'm reading a pertinent part. Subsection 3, the order is necessary to correct a scrivener's error in the terms of the will, even if unambiguous. Even if the terms are plain, the plain meaning, and are unambiguous, extrinsic evidence wasn't admissible. Yes, it's admissible now to correct the scrivener's error. Subsection B says, an order described in A3 may be issued only if the testator's intent is established by clear and convincing evidence, a heightened burden of proof. Okay. So, if not, that it's not by clear and convincing evidence, then we fall back on the common law plain meaning rule: extrinsic evidence is not admissible. So the general rule is extrinsic evidence is not admissible. Vary the plain meaning of the will. Exception: 255.451 A3 and B. If by clear and convincing evidence we can show that the terms of the will were the product of a scrivener's error. And who can show it? Who has standing to show that? What does it say? So that's right. On petition of a personal representative, that is the executor, or I guess conceivably it could be the administrator if no executor was appointed in the will. Personal representative, the executor of the estate. So a disappointed beneficiary doesn't have standing to bring that suit. Only the personal representative has standing to bring that suit. This is actually a fairly narrow exception when you think about it. And look at point 455, 255.455. This subchapter does not create or imply a duty for the personal representative to 1, petition the court for modification or reformation of will, 2, inform advisees about the availability of this relief, or 3, review the will or other evidence to determine whether any action should be taken. This is a very, very limited exception, but still, for Texas, who so firmly follow the plain meaning rule, which is probably now the minority rule nationally, the Uniform Probate Code in its various iterations allows admission of extrinsic evidence to show by clear and convincing evidence that the will was product of a scrivener's error and grant standing to the disciplined beneficiary, not the personal representative. Think about this, by the way. I'm the personal representative. I'm one of the beneficiaries. I think that the will is a product of a mistake. I think you were left out by mistake. You should have been in the will. It's in the attorney's notes, as a matter of fact. I'm one of the beneficiaries. Maybe I'm the sole beneficiary under the will, and maybe you should have been let in to take equally with me. You don't have standing to raise that. What incentive do I have to raise that, to reform the will, to divest myself of one half of the estate? Economically, I have a disincentive to do that. Maybe you're my best friend. Maybe you're my favorite sibling, and of course, I want to let you in because I'm just a nice guy. But I think this is a pretty narrow exception, actually. And remember, point 455 says personal representative doesn't have a duty to inform you about that, to review the will for a mistake, or to petition the court. And I'm the only one that has standing for personal representative. So it's a pretty narrow exception. Supposedly, this statute was enacted. If you read on 221 of the statutory supplement, 221, page 221, subchapter J, judicial modification and reformation of wills. In his statutes in context, his little discussion of this recent change, Professor Beyer says that this says in a major change in Texas law. Well, it's a major step, although it is a major change, although it's still a fairly narrow exception, isn't it? Otherwise, we fall back on the plain meaning. He says, courts have now been given the authority to modify and reform a will, even if the will is unambiguous, effectively overruling the Supreme Court of Texas in San Antonio Area Foundation versus Lang. In San Antonio Area Foundation versus Lang, what were the facts? What was the alleged mistake in that case? Why didn't they admit extrinsic evidence? I'm not sure that, I don't know how the statute, why does the statute come into play in Lang? How is Lang different than guilty? What was kind of generally going on in those two cases? One, they admitted extrinsic evidence, the other they didn't. Incidentally, I think guilty was wrongly decided under our old law. Under the old law, Lang was correctly decided, guilty was wrongly decided. There's a difference between those two cases. That's the only difference. It was a will prepared by an attorney, and apparently the attorney had somehow made a mistake in the way he drafted the will. There was something in his notes to show that he drafted it wrong, that it wasn't supposed to be the way that it was, and extrinsic evidence could have shown that there was a scrivener's error in that. What happened can you tell me just kind of briefly what happened in guilty as opposed to what happened in Lang? What was the mistake or the alleged problem? Right, in guilty, right? She said she owned the testator's homemade will, holographic will. She owned some livestock with her son, a particular son, T.O., I think, half and half. And then everything else she owned outright, she wanted to give him, apparently, a life estate in all the rest of her property. The one half of the livestock that she owned, she wanted to give to him outright. So now he would own 100% of the livestock. Everything else she wanted to have a life estate in. But she didn't say all the rest of her property. What did she say? She said her personal property. And as the dissent says, we can't admit extrinsic evidence to vary the plain meaning of the will. The term personal property, what about her real property? She died intestate as to her real property, right? And that's what the dissent said. She should have died intestate. Words have a clear established legal meaning. Personal property means personal property, not real property. She said personal property to him, not real property to him. She died intestate as to real property. But the court bent over backwards in guilty to say, well, she was uneducated, she didn't know about the law, she was a lay person, she was a homemade will. It's clear they admitted extrinsic evidence to show that when she used the term personal property, she meant everything that she owned outright, real and personal, as opposed to the livestock that she only owned a one-half interest in. Clearly, I think the dissent was right. Under the old rule, the plain meaning rule, I think the court got the case wrong. So, in San Antonio Area Foundations versus Lang, a will drafted by the attorney, what happened there? And notice, did Lang overrule guilty? I don't think so. I mean, the court didn't expressly overrule it. So I think the only difference was an attorney drafted the will in Lang. What was the problem? She left, the testator left her nieces and nephews. What? Yeah, she only owned part of the property, but it was. And what else did she have? She sold some of it. And what was the term that was at issue in the case? What? Well, ademption, but that wasn't. She didn't use it. What did she use in the will? Yeah, she said real property, and the question was she had sold her interest in the Prue Road property, and she didn't have real property anymore. She had a note and I guess maybe some cash, and she had a note that she had taken for the proceeds, basis of the sale. And the note that she was financing wasn't real property anymore, but it was personal property. And they said, oh, no. When she said my Prue Road property, when she said real property, we in the family always referred to that property, even though she had taken a note. She still referred to that as her real property. The court said, we don't care what you referred to it as. She said real property. That real property was gone. Ademption is now personal property, and you don't take the personal property. The residuary beneficiaries, the charity, the foundation, takes that property. We wanted that extrinsic evidence. I don't see how 255.451A3 changes the result in the Lang case, unless apparently Professor Beyer thinks that the attorney simply made a mistake, and when he said real property, he meant to say something like real property. Remember, ademption, we can draft around it, right? So he could say, the testator could have said, my real property, or the proceeds of any sale of real property, or the proceeds in the notes if I'd sold the real property. Then she could have drafted around ademption, and arguably the attorney failed to do that, made a mistake by not doing that. And if that was the case, then we could have taken extrinsic evidence to vary the plain meaning of the will to show what she intended, if it was a product of an attorney's mistake. If it wasn't the product of an attorney's mistake, or the drafting first party's mistake, would be the testator, then we can't take extrinsic evidence to vary the plain meaning. We still fall back on the common law plain meaning rule unless it's the product of Scrivener's error and the personal representative raises it, and we can show it by clear and convincing evidence for 255. Okay? Question about that important change. I'm going to tell you this. I'll figure out a way to ask you about this important change on the final exam. I can also tell you this, for those of you who are taking the bar exam in the next year or so. I'll bet the bar examiners can figure out a way to do that too. This is the exact kind of change in the law the Board of Law Examiners love to just throw in as an issue or sub-issue or something like that on the Texas essays. So just kind of look out for that to happen. This is a pretty important change because Texas really held to the common law rule. It's a fairly limited exception, but it's an important exception because attorneys make mistakes in drafting wills all the time. And as we'll see at the end of the class, maybe via video, because we probably missed that class right after Thanksgiving, I may have to make it up. I'll make it up probably via video. The very last chapter on malpractice, Texas still follows the so-called privity barrier. That is, a disappointed beneficiary cannot sue the drafting attorney for negligence, for malpractice. But now, at least, if the attorney was negligent, if the will was the product of the Scrivener's error, they left someone out, they put in the wrong language, they gave the wrong thing to the wrong person, if the personal representative can show that by clear and convincing evidence, we at least can reform the will, so the right beneficiary takes. You see, the personal representative doesn't have to bring that suit, and they may not want to do that. Okay, what else do I want to say about this? I don't know, that's a lot of notes. We covered a lot more. How far did I say for y'all to read today? I just covered. And what I expected to spend an hour on, I think I just covered in about 25 minutes. We can talk more about the bars now. No, I've got a lot to say. Let's talk about the plain meaning rule and whether it's a good rule or not. Let's forget well, let me ask you this. The change that was just made, 255.451, subsection A, particularly A3, the Scrivener's error, allowing extrinsic evidence allowing the court to admit extrinsic evidence to reform or correct a will, a Scrivener's error in a will. Do you think that's a good rule? Do you think that's a bad rule? Do you favor the old common law plain meaning rule of not going to admit extrinsic evidence, even if it's a product of an error, too bad, so sad? Or do you think many states, there are a fair number of states that have rejected the plain meaning rule entirely and allow admission of extrinsic evidence to correct any error in the will, whether it's a product of a Scrivener's error or not, so long as it can be shown by clear and convincing evidence? What do you think? What's the best rule and why?
Well, everything seems to be based off of the testator's intent. I think if there's a mistake that's not their fault,
That's right. If there's a mistake that's not the testator's fault. The guilty case, is that the testator's fault? Yeah, I would have just said to the old biddy, the dead old biddy, my gosh, too bad, so sad. You die intestate as the real property. I think the dissent was right. There's a clear meaning of real property versus personal property. She used the wrong words. Too bad, so sad. We shouldn't be second guessing that. But maybe I'm wrong. Maybe I'm being a bridge even on that, because after all, we want to further testator's intentions. We don't want to frustrate testator's intentions. What's the argument? So the argument against the plain meaning rule is, let's take extrinsic evidence to show what testator really intended, maybe by a heightened burden of proof. Most of the states that have varied the plain meaning rule require a higher burden of proof, clear and convincing evidence as opposed to preponderance. So let's do that if that will further testator's intentions, because we want to know what testator really wanted, and we want to be able to distribute the property the way she wanted. Okay, that's one good argument. I'm reasonably persuaded by that argument. So what are the arguments against that? What are the arguments in favor of, frankly, the old plain meaning rule? Don't even do the Scrivener's error, the old plain meaning rule. Yeah, we don't want judicial intervention. Why not?
well, I mean, in a lot of cases, you're right. You And usually, it really seems like the case can go one way, and there's especially when we have to.
In case of what, I'm sorry.
It feels like the case can go one way, and if you apply the law and say it looks like it's going to go one way, and they just find ways to justify certain things and certain others.
So we don't want judicial interference. We don't want the floodgates of litigation, right? I mean, this is the thing. The plain meaning rule is efficient. We know what it is, and the court got guilty wrong. The guilty court got the case wrong. We know what it is, and if the testator used that word, or if the scrivener used that word, too bad, so sad. We don't want to open the floodgates of litigation. We don't want courts second guessing these kinds of things. We don't want disappointed beneficiaries coming in and bringing these kinds of suits because it's going to tie us up. So, what's the best? I mean, let's just poll. Let's just sit, okay? And we're gonna use our clickers, right, to vote. And I want you to vote. I guess there are three possibilities. One is the old plain meaning rule was very good. It was efficient. It was clear, predictable. We knew the results. Sometimes maybe it seemed to get the cases wrong. It didn't further testator's intent. It frustrated testator's intention. But at least everyone knew where we stood, and we're not tying up the courts, floodgates of litigation, not tying up the courts with frivolous suits. That's one thing. The other thing is, no, by clear and convincing evidence, we can go further than 255.451, and any disappointed beneficiary can bring suit to reform the will if they can show by clear and convincing evidence the will was a product of mistake. Or, I guess this is in the middle, right? It's clear and convincing evidence that only the personal representative can bring suit, and it's only to correct not any mistake, but only if it's the drafter's error, which is the most common form of mistake after all. So, vote for the old plain meaning rule, efficient. The new rule, Scrivener's error rule, for the personal representative bring suit, or disappointed beneficiary can bring suit to show by clear and convincing evidence that there's a mistake in the will, not just the personal representative, it's not just the Scrivener's error. What do you think? Go this far? Wait, no, go this far to further testator's intention. Okay? This strikes a pretty good compromise. Or let's go back to the old plain meaning rule and let's this nice, easy, bright line judicial efficiency. And it looks like most everyone voted, thank you very much. And it looks like the class kind of split three ways. I have to admit, I can, I'm a good liberal. Hell, I'm a socialist, and I think that this is a good. I think this is a good thing because we want to further testator's intention. I see that there's a lot to be said for the old rule. Maybe the new Texas statute is a good compromise. I know that my colleague Terry Helge drafted this language. Actually, she was the one who suggested this. She was part of a state bar committee that suggested some changes to the estates code, and this was the change that she wanted. And she wanted it to go further. She wanted to allow any beneficiary by clear and convincing evidence to show that the will was a product of the mistake. Not even necessarily just the Scrivener's error, but the legislators said, oh no, that's too far. It has to be personal representative. We don't want to open the floodgates of litigation, and it has to be limited to a Scrivener's error. The Scrivener's error is the most common form of mistake. The attorney who drafted just got it wrong. That's the common form of mistake in the will. So, all right, fine. I think that clear and convincing evidence and a heightened burden of proof protects enough against the floodgates of litigation. That's just my opinion. I would go all the way here, but okay, the legislators were fairly modest.
It seems like it's going in the middle, but for the most of the people, I guess, I'm from up north, so there's a lot of farm families and stuff, and usually the personal representative is also thinking under the will.
Yeah.
So they have a vested interest, but if they're a personal representative, why couldn't they said, oh, well, they actually meant I was supposed to take 90%, not Lisa or whatever, and that's a Scrivener's error, so they just swap the names, and I can show proof, but they're
Who is I'm sorry.
so the executor is also
You're the executor.
and I'm taking 10%, and I get my executor fee. Farm dad didn't like me very much, we never took it seriously. But sister was there all the time, 90% given to her.
And dad made a mistake and it was 90-10 the other way around?
Right, but I benefit there's no,
So you have no incentive to bring that suit, right?
but
That's my
I'd be the
point.
person responsible for it.
But when you say, what do you mean responsible?
One of you would think that the executor would be the one who would be responsible to make sure that it was executed for intent.
No, the testator is the one who's responsible for making sure that executed the way it's written on the paper.
Right.
Not the intention. And 255.455 makes that clear, right? The testator, that the personal representative doesn't have any duty to examine the will for an error, to let the beneficiaries know that there's this remedy, or to bring suit himself, and he's the only one who has standing to do it.
Right.
So it's a pretty narrow exception, and I think there are going to be a lot of times when the executor, who's one of the beneficiaries, isn't going to want to bring in an omitted beneficiary, so shows the will as a product of a mistake that might reduce your PR.
Oh, I was just gonna say, I'm definitely for the one that is open for all the beneficiaries or whatever. Because ultimately, if you're always looking at wanting to get the testator's intent, narrowing it so much really doesn't help that.
What's more important, that we are trying to further testator's intention, or that we don't want to open the floodgates of litigation? We want judicial efficiency, and those are the two things that are in tension here. Judicial efficiency, no floodgates of litigation. Plain meaning rule. Further testator's intention, any disappointed beneficiary who can show by clear and convincing evidence that the will was a product of mistake. You're still going to have to bring that forward. Should have standing. It's not just Scrivener's error. It's not just the PR.
But I think I think that it's not just those equally. I think it's also that it's his property and it's our property. The government should be able to tell us, oh no, sorry, they made a mistake, and because it didn't fit this narrow rule.
When you say
you don't
his
get
property,
it.
who's his property?
Well, the tax orders and then the beneficiaries. Then it limits the beneficiary just because of this rule, because it's like, oh, we don't want to deal with that. When it's like, oh, this is my property. This is supposed to be my property.
Well,
it's property rights.
But it isn't based on what the will says, right?
Because of a mistake.
Because of mistake. We're going to have litigation to show that. So, I mean, I favor this too. As I said, I'm a socialist. But,
I don't
or at
think
least
it's a socialist thing.
no, I'm not. It's not a socialist thing. It's a pro-lawyer kind of thing. That's full employment for lawyers.
I think
right?
it's a pro-property.
It's pro what the testator intended. I'll say this: you had a tell me you are Mr. Latimer, right? Okay, Mr. Latimer. Yeah.
Practically speaking, it seems like you could pretty much consider anything in Scrivener's error. It's just like, can you help us understand the distinction between Scrivener's error and some other kind of
The guilty case is a perfect example, right? If the testator herself isn't a scrivener, if the scrivener is a third party, and she just used the language in a particularly unusual way, and she was mistaken as to the meaning of that, like the legal meaning of personal property as opposed to personal and real property. And so, if that's not a scrivener's error, it might not correct the guilty case. Depending on what we consider a scrivener's error, if the testator made a homemade will and she just didn't understand the effect of the word she used, she was the scrivener. So maybe we can interpret this very broadly. There's one difference: only the personal representative under effect. Only one person who has standing, as opposed to any disappointed beneficiary. And for the reasons that Mr. Cook just said, the personal representative, especially if she's a beneficiary, might have a pretty good incentive not to bring that suit. They're the only ones with that standing. So no duty to do it. I don't know. I think this is a tough one. I will say this. Remember, when it comes up on the final exam, and it will in some form or fashion, the plain meaning rule is still the rule in Texas. If the will is a product of a mistake, but the language is clear and unambiguous, extrinsic evidence is not admitted to correct the will unless the personal representative brings suit can show by clear and convincing evidence that it's a product of a scrivener's error. However we might interpret that. But there are all sorts of times where we allow extrinsic evidence to be admitted in a will situation. Let's list some. Some of them we've talked about, some of them we haven't talked about. We'll talk about it in the next week or so when we get to the will contest materials. When do we allow extrinsic evidence to be admitted? When must extrinsic evidence be admitted, for example? To show what? Say what? Yeah. Blatant ambiguity. Patent ambiguity. What else? Extrinsic evidence what? What about an extrinsic evidence mistake? How about if the will was revoked as a product of a mistake, based on a mistake? Dependent relative revocation, that we just talked about the other day. We admit extrinsic evidence showed that the testator didn't really intend to revoke the will. That was a product of a mistake. We might disregard, a court might disregard or cancel the revocation and say that the will that was mistakenly revoked really is still in full force and effect. What else? When else do we admit extrinsic evidence? Blatant patent ambiguity. Dependent relative revocation. What else? I've got. How about what? How do we prove a will? What do we have to prove up to show in order to get a will admitted to probate? What if the will is not self-proved? What do we have to prove? What? What do you have to prove? You don't have to look up. Just yes, the testator had capacity. The testator was of sound mind and had testamentary capacity over the age of 18 when the armed forces or had been married. Right? And we take extrinsic evidence to show that. What else do we have to prove up if the will has testator has testamentary capacity and well, that's right. We did testator really have testamentary intent? I guess that's part of capacity. I'll lump that together, but right, that's one thing. We take extrinsic evidence to show that. Yes, you would have to prove. Let me go a little bit broader than that. Let's say due execution of the will. The will was duly executed, right? The testator signed it. That was testator's signature on a holographic will or on another will. That the witnesses, if it's an attested will, it's not a holographic will. The witnesses were in testator's presence when they signed the will. Now, some of this can be done by the self-proving affidavit. If that's extrinsic evidence, you don't see any of that on the face of the will itself. Look at this. We're going to also, I'm going to tell you, there's some other things. When we get to will context. UI, undue influence. We have to show, we get extrinsic evidence to show, again, to prove that the will is a product of undue influence. ID, an insane delusion. Fraud. Duress. If by extrinsic evidence we can show that a will that's clear and unambiguous on its face is a product of one of these things, undue influence, insane delusion, fraud, or duress, in some ways those go to mitigating testator's testamentary capacity or mental capacity, right? Any of these things, then we can reform or indeed maybe strike down the entire will. So, reform it, correct it, we can ignore a revocation of it, we can strike down the entire will if it wasn't duly executed, testator didn't have testamentary intent or mental capacity, if it was a product of one of these other things. So we admit extrinsic evidence all the time. Now, are we still worried so much about the floodgates of litigation over here, especially if we would have to show this by heightened burden of proof, that the will was a product of a mistake, that testator meant something else? I'm not as worried about this in light of admitting extrinsic evidence in all these cases. But I still admit fully, if the will isn't the product of any of these other things, and the will's language has a plain meaning, it isn't ambiguous, there's something to be said for the old common law plain meaning rule, which doesn't open the floodgates of litigation. I'm just not convinced the floodgates of litigation would be open. I'm not convinced they aren't already there. But that's just my personal sentiments. Right, I'm glad to see that the clock hasn't advanced any, and we still have a good, 75 minutes or so. No, we don't. I know we don't. Okay. Let's talk about, if there are no other questions about this, it's probably what I want to say about the plain meaning rule. And this, I think it's a fairly small exception, but it can be an important exception in 255.451, allowing personal representative standing to show by clear and convincing evidence that the will's language is a product of the scrivener's error, the drafter's error, and allowing the court to reform that will to correct that mistake. By the way, well, okay, that's probably 223. If there's no more, let's go ahead and turn the page literally and figuratively. Let's talk about integration for a second, external and internal integration on page 223 and 224, and then we'll go to incorporation by reference, and I'll spend a fair amount of time on that important doctrine. External integration. External integration means this. All valid testamentary instruments that are executed by the testator, all valid instruments, not the invalid ones, not the ones that were duly executed or testator didn't have capacity or there was under insane delusion or undue influence or anything like that. But if a testamentary instrument has been validly executed by a testator, legally executed, all of those instruments taken together form the testator's legal testamentary intention. That is a will and all of its codicils. Okay. So each of these instruments should be properly executed and dated, and ideally, the latest one, say the latest codicil of the will, should make specific reference to all earlier ones, and they should be found together in one place, so there's no question about what the testator really intended. The testator really intended for this to be a codicil or not. So on note 1 on page 223, some examples of external integration have already been discussed in this course. What are they? The main one is the will and all codicils of the will. Right? That's one we talked about a lot. Note 2, upon testator's death, a valid will and a valid codicil are found. Which documents may be admitted to probate if the following are true? The will is a formal, that is, attested will and a formal attested codicil. A. B. A formal will and a holographic codicil. C. A holographic will and a formal codicil. D. A holographic will and a holographic codicil. A, B, C, and D, those combinations. Which one, if any of those combinations, are not admissible, assuming they're all valid? What says, Professor Byer says, valid will and valid codicil. That means duly executed, legally executed by a testator with testamentary intent and testamentary capacity. You get that on a final exam. If I say they're valid, they're duly executed, you don't have to prove that they're valid, or you don't have to prove to do execution. Just take it for granted. Which, if any of those things, cannot be admitted to probate? What do you think? Who wants to tell me which one of the ones can't? A, B, C, or D? Which combination can't be admitted to probate?
It seems like all of them, I think, should be, but I think C might be.
Holographic will and a formal codicil. Why do you say that? I think all of them are admissible. Okay, I think all of them are admissible. What gives you pause on C? Is it because of what you read about incorporation by reference? Yes, I think so. And I can see, and that's great. And that's I mean, take this in the nicest way possible. That's incorrect. When you said it's incorrect, but that's a good mistake to make. That's a very instructive mistake. That's a teachable moment. Because if they're all valid, then they're all admissible. It's kind of a trick question. It's almost a tautology. But I can see why alternative C might give you cause for pause, and we'll talk more about it in a moment when we get there. It's not the first case. It's not the all-day case. It's the Henson versus Henson case, right? Yeah, it's the Henson case that gives us cause for pause on that. Okay, so we'll get back to that. Thank you, Mr. Madden. I appreciate that. Yeah, the answer on 2, A, B, C, and D, they're all admissible. How about internal integration? Internal integration is something different. It doesn't mean the will and all of its codicils. It means every piece of paper that was present at the time the will was executed, that was intended to be part of that will, is part of that will. As opposed to external integration, which is going to come back a week later, a month later, a year later, 10 years later, and execute a codicil. That clearly was subsequent in time. But internal integration is when we're executing the will, all pieces of paper that were present at that time that testator meant to incorporate, to be part of that will, to be integrated into the will, are in fact integrated into the will. Well, gee, that one seems obvious too. Why would there ever be a problem? You see on the bottom of 223 and on 224, Professor Byer gives you some ideas about how to minimize internal integration problems, and they're largely self-explanatory. Careful practitioners in the field generally follow these practices or these guidelines because sometimes there are internal integration problems. Because of sloppy execution of the will or sloppy drafting of the will. It may be unclear whether a piece of paper that was physically on the table at the time testator executed the will on the table, was that meant to be part of the will or wasn't that meant to be part of the will? Because it's sloppy, because it's unclear. The other problem with internal integration is, were those papers really there and intended to be integrated in the will at the time testator executed the will, but someone slipped them in later? There's been fraudulent tampering with the will. Those are the big issues and the big problems. And the note 1 on page 224, and that case is a mess, and I'm not really going to go into that question. I don't like it a lot. It's sloppy. But basically the case held that all of those pieces of paper that were basically all present when the will was executed were intended by the testator to be a part of the will. Promissory note, prepared on a printed blank, part of the will. A sheet of paper apparently taken with a small writing tablet. Please accept this. Sick. An envelope, which is horizontal words Henry Boyce. Notes, those things, were they intended to be part of the will? Weren't they intended to be part of the will? Guess what? We're going to go to court and figure that out, unless we can make it clear which pages were intended to be part of the will and were there when testator executed the will. So I don't really test very much. I can't recall the last time I tested on either external or internal integration, but that can actually be a problem, particularly internal integration can be a real problem because of sloppiness. And just try not to let that happen to your clients if you're going to practice in this area. If you're not going to practice in this area, still not try not to let that happen to your clients. Okay, that's probably all I want to say about both external and internal integration. Now let's talk about incorporation by reference. I see I really just have another 73 minutes. And no, that joke never gets old. If only time really would stop like that, it would be so nice. We wouldn't even have to have class. We didn't have to make up any class. We could just stay here for 24 hours and get through the rest of it. You'd like that, wouldn't you? No, I don't even think I'd like it. So, all right, let's talk about incorporation by reference on 225. Incorporation by reference is a pretty interesting exception, and when we get to facts of independent significance next week, you'll see it's another exception that allows something, some instrument, some piece of paper that was not physically a part of the will, wasn't physically internally integrated into the will, nonetheless, it can be a part of the will, form part of the testator's last will, even though that piece of paper itself wasn't executed with the required formalities under the law. That's the whole point of incorporation by reference. So, and the Alday case is a great example. Great example of incorporation by reference. Incorporation by reference, IBR, that's how I abbreviate incorporation by reference. So, this external document that isn't executed by testator, maybe, or by testator and two witnesses, or wholly in testator's handwriting, this internal document can be incorporated into the will by reference, even though it hasn't been properly executed. Alday, what happened in the Alday case? What was the issue there, and why is it a good example of incorporation by reference? And then we'll take the Alday case. One? Look. Can I let okay. Thank you. Well, maybe it's Miss Mahisa. She has been.
She's on call.
But she's on call. But she's above and beyond call of duty. She's been like so nice to help everyone out all week. So you can backstop her if you don't mind. Okay. You're not going to need any backstopping, are you?
I mean,
it just depends. Okay. All right. That's what happened. That's what happened. What were people complaining about? What was the will?
Okay.
What was the will portion of the issue? Portion of the will issue.
So at the time the will was executed, the testator, he executed the contract with his business partners, and
I think it was she. Actually. That's okay. And which is 1912. This is more than 100 years ago, and it's kind of unusual that a woman was in business in Texas in those days. So I like to point that out when it happens. Or did not. So,
So
she executed a will, and she executed a contract with her business partner. It was a partnership agreement, right? Okay, it was a business agreement.
So after ending the business agreement, it was after the death of any of the partners, the business would be carried on.
That's right. After the partnership agreement said after the death of any of the partners, the business would be carried on. Okay. And was there a time limit on how long the business would be carried on? I think it was for 5 years after the death of any of the partners, right?
Yeah.
Otherwise, because the old partnership law, the default rule, I think it's probably still the rule under general partnership, is absent agreement to the contrary, the death of any partner terminates the partnership. Okay, so she died first, the partnership would be terminated, but they had an express agreement to vary that rule, the default rule, that says be carried on for 5 more years. Okay, so who's complaining about this?
Her beneficiary.
The will beneficiaries, okay? And what do you think they want?
They don't want that partnership carried out.
They don't want the partnership carried out, they want their money right now, don't they? They want it terminated, and they want their money right now, okay? So they're saying, that's not part of the will. You can't have, we can't. You can't refer to that. And why are they saying that's not part of the will? What did her will say about that?
About
It's
the,
page 225. It's that second paragraph, item 14. Now, you pretty much said it. But let's look at the exact language.
you want me to read it?
Yeah, the exact language, yeah. And I'll stop you on the, it's item 14, right, in the will.
Okay.
See right there on page 225?
Yeah.
Okay.
Oh, just read the whole thing? Okay. So, item 14, I express the will, declare and direct that the instruct,
It's between me and all these people. That's the
Yeah.
partnership agreement. Go on. Shall.
Shall be in all respects adhered to, observed, and carried out.
Period. Okay. All right. Then then I'm going to get back to which agreement stated blah blah blah. Okay. So she says in my will, I specifically state that partnership agreement, in all respects, including continuing for 5 more years, shall be carried out. So the beneficiaries say, wait a second. The partnership agreement isn't part of the will, right? Partnership agreement wasn't executed by testator and 2 witnesses knowing that it was a will. Now, interestingly enough, you can make an argument because there were several partners. Maybe there was enough. Maybe there were 2 people who could have constituted witnesses, even though they didn't know that they were witnessing her will. Was the partnership agreement really for will? Was that written with testamentary intent? Was that intended to have property at her death? No, that was intended to carry on a business during her lifetime. So, all right, I guess it was a partnership agreement. It really wasn't a will, and therefore, her will can't override the fact or can't refer to that partnership agreement. Can it? Or can't it? What's the court saying? Why is that partnership agreement, in effect, a part of the will?
Well, the court, rejected a beneficiary's argument, and they said that the contract was incorporated by reference.
That's right. That contract, that partnership agreement, is in effect a part of the will. Legally speaking, as a practical legal matter, it is a part of the will because it has been incorporated by reference. So, note 1. Note 2 on page 227. Order requirements must be satisfied to successfully incorporate a document by reference in a will. Can you tell from the case, Ms. Anderson, what's required? There are 3 elements. And I think all of these things are present in this case. You kind of guess what's on. The case doesn't really give us the full rule.
Let's see,
Doesn't give us all the elements.
let's see, let's,
3 elements. This is what it takes to incorporate an extrinsic document, a document that's not part of the will. It wasn't present at the will execution. It was maybe not even executed with testamentary intent or duly executed. That was the partnership agreement. There's no testamentary intent there. He wasn't passing property to her death in the partnership agreement. The partnership agreement was ongoing during her lifetime to operate a business.
well, the document must be already done before the will is done.
Here it is. The document to be incorporated has to be in existence at the time the will is executed. It has to be in existence, and it can't be changed after the will is executed. So it's got to be pre-existing. And at the time the will is executed. It can't be changed later on. If it is changed later on, maybe it can be incorporated by reference, but those changes can't be incorporated by reference. Okay, this is a document that's not duly executed. If the document is duly executed, by testator and the appropriate number of witnesses with testamentary intent, then it can stand as a will or a codicil itself. This is what we have an extrinsic document that's not duly executed. Has to be in existence at the time the will is executed. What else? Yes, that's correct. That's one of the most important things. How about
the will? I guess it must be the will's intention for the reference for the document.
The will has to show a clear intention to incorporate that document by reference. Incorporate by reference. Right? So it has to be in existence. The will has to show a clear intention to incorporate by reference. And what else? You're right. This is it. So this is 2 out of 3. One more else.
Does the will need to be specific about what the document is?
Yes. The will has to clearly identify, clearly ID the document to be incorporated, the instrument to be incorporated by reference. Why were all those things met in this case? Clearly they were met in this case.
Well, because she was very specific, like she said exactly well, they all agreed exactly what they wanted to happen after one of them died.
Well, that's true. That's true. But that wouldn't be good enough to incorporate it by reference, right? Yes, that's certainly true. The will might not have incorporated that. But just take me through these elements. Was that document in existence when the will was executed?
Yes.
When was the will executed?
Was it September 14th?
September 14th, 1910 was when the document was executed.
November 10th.
When was the will executed? November 10th?
Or
Did you say when the will was executed? Well, the will was executed later. The will was clearly executed later. Okay. So yes, the document was executed, was in existence at the time the will was executed. Does anyone see when the will was executed? I don't think it says that, does it?
no, that's
Yeah, it was simultaneous.
It was simultaneously?
The evidence shows the co-patron executed the will and contract simultaneously.
Will and contract simultaneously. All right, I'm going to change the facts a little bit. She executed the contract first, and then she executed the will. All right, so it was in existence. She executed the will first, and then the contract. You might have a problem, although the court might have said, well, it was all part of one transaction, and really, in effect, it was pre-existing. But it has to be in existence at the time the will was executed. Was there a clear intention to incorporate it by reference? Sure there was. Why? What was the language in the will that showed, Ms. Anderson, that there was clear intention to incorporate the contract by reference?
what is the just there?
Well, yeah, it was. So what was it? And what was that again? Because I've forgotten. But that
I expressly will declare and direct that
the
the instrument between me and all the other people shall be in all respects adhered to, observed, and carried out.
adhere to, observe, and carry out. That's clear enough. It doesn't have to say it. And by this reference, I expressly incorporate that document into this will. Well, that might be more careful to do that. You don't have to say that. That was, I think, clear enough intention to show this document was incorporated by reference. It was in existence. The testator showed intention incorporated by reference. And what else? It has to be clearly identified.
Yeah.
Is it clearly identified?
Yeah, because you said the document between me
Between
and all.
us, you identified all the people in the date. Okay, but that would be the same date. Okay, there it is. 1, 2, 3. All things, all three of these elements were met, and therefore this document was incorporated by reference. Okay, those are the elements. Mr. Grant?
In your list of extrinsic evidence, I can't help but think, when you introduce extrinsic evidence here, what if the document that is referencing can't be found? At the time of its probate.
Okay, what if the document that's referencing cannot be found? Let's see here.
It may be this next page, because I was completely lost on it.
Note 5 on page 227. Note 5 on 227. That says work depend upon the business. Hamilton says the least go with door tax. That document couldn't be found. What's that say? Trim versus Daniel, ladies and gentlemen. It's about the 5th time we've come back to this case. So, does that mean I will ask you about Trim versus Daniel in some form or some fashion or final exam? You bet it does. But I'll bet I can slip it in so it happens. You don't even know I slipped it in. It's wrong. But it's okay, because I got to separate the A from the B from the C somehow. Okay, you're going to be the first class that's a small class. Be the first class that doesn't miss any of those problems, okay? But that's your question, Mr. Brown, right? Remember Trim versus Daniel has a guy who, 10 secrets to a happy marriage or to a happy relationship. He had a couple of common law wives. And he wrote, everything I have is yours, darling, or I leave everything to you, darling. And Bernice or Vera or Burnett or whatever her name was, Daniel. And he also wrote on there, handle pursuant the incomplete will Doris had. They couldn't find an incomplete will. Okay? And the court just said, well, that's some extraneous provision, some reference that has no testamentary intent, and we'll just ignore that reference. But that was a holographic will that was written in his handwriting. It was signed. If the court had held there was an intention to incorporate some document by reference, and if they had held that it was in existence and that it was clear enough that they couldn't find it, what do you think the court would do with it, Mr. Grant? They couldn't find it? They really couldn't find it? Do you think they deny the will probate, or do you think the will would be probated and they just ignore that?
They probably ignore it.
I think that's right. I think, in effect, that's what happened in Trim versus Daniel. They didn't have to get to the incorporation by reference problem because they said, well, we can't find it, so it's a moot point. We'll go on. We don't know what the hell he's talking about. That wasn't clear enough. But if they said that was clear enough, we just don't know where it is, then I think they just have to ignore it. Nonetheless, I think it was both. So, good question. Let's look at some of these other notes. Note 3 on page 227. Does the incorporated document need to be legally effective that is duly executed, signed, witnessed, etc.? No, that's the whole point of incorporation by reference. That other document doesn't have to be executed at all. It doesn't have to be signed at all. It can be anything. I can incorporate this seating chart by reference if I want to in my will, and I hereby leave $1,000 to all of the people named in this seating chart dated such and such a date. Okay, I can do it sweet. Okay, but we don't. That was a I said that earlier, and we don't admit oral wills anymore, right? But anyway, I could do that. This isn't even signed by me. Wouldn't have to be signed. Wouldn't have to be executed. Wouldn't have to be witnessed or anything like that. That's the whole point of incorporation by reference. You start to see what kind of a big exception that is to do execution of a will. Yeah. How about Note 4, testator's will states, I hereby give the remainder of my estate in 7-day advance for nomination, general conference, Washington, D.C. for a Hughley Memorial Hospital. Detailed described document regarding the Hughley Memorial attached. Has a valid incorporation by reference taken place? Has simply attaching a document that's referenced mean that does that show a sufficient intention? The document is actually attached, presumably it's in existence, presumably it's clearly enough identified, but that it has been clearly enough shown that there's an intention to incorporate that by reference. There is a Hughley Memorial Hospital just south of Fort Worth in Everman and Burleson, right, on I-35. The court must have held that that was sufficient incorporation by reference. Held? No, not sufficient to incorporate it by reference. I don't know how Hughley Hospital got the money. There must have been some other will challenge, and there must have been some other kind of compromise. But that case held that's not sufficient. Now, merely attaching an existing document and identifying the existing document isn't clear enough to show the testator had the intention to incorporate it by reference. The testator had to do something more. And I hereby incorporate, by this express reference, that document that's attached here too into this will. That's clear. And that was the problem. I handled pursuant to the incomplete will that Doris has in Note 5. The court said, well, we don't know what they're talking about, and that wasn't a good enough reference to identify the instrument or to show a clear intention to incorporate it. I don't know. Maybe that was enough, but you can't find it. You just can't find it. Okay. Let me talk about, in the 5 minutes that I have left, oh, heck. I have a lot I want to say on Henson. I also want to talk about pour-over wills. We're skipping the material on pour-over wills, but I want to talk about pour-over wills here. And still have 73 minutes left. Wow.
We
No, it's hot.
went
Often
over
it's not
last
funny,
time.
it's hot. What?
Remember we went over last time?
And we did go over last time, didn't we?
20 minutes.
20 minutes! 73 minutes! Stop it, just slam me, slam me. All right, this is a good stopping point. When we come back, I want to talk about pour over wills. I think I asked you to look at 254.001, 254.001 of the estate code. That's in your, I think that's in your syllabus. Do take a look at that, 254.001. We'll do that, then we'll do the Henson case, then we'll go onward and upward, facts of independent significance, and maybe, just maybe, conceivably, possibly, we will finish this chapter. And how far did I tell you to read in the next chapter? Through page 270? Is that right, 270, the next chapter? I doubt we'll get there. I don't think we'll finish this chapter. Matt, Norm, do you think we'll finish this chapter? Absolutely not. You're saying that because you're trying to be nice to me. Okay. All right. We'll pick up there. I want to talk about pour over wills. Then we'll pick up with the Henson case and the notes afterwards next time. All right. Now we're even. I kept you over a few minutes last time and 2 minutes under this time. We're even. Okay. But I get 73 extra minutes next time. Have a good weekend, everyone. And remember, first row you're on call on Tuesday, second row you're on call on Thursday. Everybody sits on that much, but one day.
Well, Charles, how are you?
Oh, yeah.
Have a good weekend. Man, we're reading this book, huh? We sure are reading it.
What do we do from one
That could be it.
Is there like a news page for Texas A&M? Like a news feed, RSS feed? Oh, Jessica's here. Yeah, she's hiding in the back. I was going to send her notes, but...
Okay, we can't have our program.
This weekend, we got next week, I've got to start for the law room. Following weekend, I've got a mock trial. This Thanksgiving weekend, Veterans Day. Be careful going home, it's bad.
So I am testing the air. I was out of the real. I know your old dad on his deathbed. I don't like your old dad. So I wait for the hospital. I find it. I drive to the bill. I cut 6 pedals.
And then, what was so funny is I went to her shop in Fort Worth for the first time. I was invited to the opening of it, but it was like last year or something like that, and the kids were sick, so I couldn't go. And I don't remember, I just don't yeah. My mom has a lot of actually, it's for baby shower. Yeah, thank you. I asked him ahead of time, if I could come in later. Yeah. I had my friend she was apparently going to Florida, and she got stuck here on her layover because they had a connection flight that the tornadoes disrupted. Well, apparently there were tornadoes. Actually, as I was taking her, there was a warning as I was leaving. No, as we were leaving the airport, we got stuck in traffic for like an hour and a half, and we were sitting there, stopped dead because there was an accident. And as I'm sitting there, my phone buzzed the tornado warning, take shelter now. I was like, oh, no one there. I'm like in the middle of the place.
John Smith here, right now.
Such is life.
We're close to be at 8:15 and then they bumped that back. You're up there and then started flying right in.
Yeah, I got stuff.
Did you? Yeah.
Glad you guys are safe. It's
Yeah.
tornadoes are kind of scary, you know what I mean?
I was hoping that I'd actually see one for once. My whole life, all I wanted to be was a storm chaser.
Yeah.
Never seen a tornado. I know, huh? Doesn't it?
Wow, that's brave, but I once saw a
Usually I'm in
mini.
Lawsville instead of storm chasing, so not that brave.
Well, yeah. Well, I mean, maybe this is the place to chase some
Different kinds of storms.
different kinds of. I once saw a mini tornado. It was like as big as me, and it was just like that's it. I think it was just like a gust or
Oh,
something.
not cloud.
No, but it was like, you know how you scribble a tornado?
Dust devils.
I thought there was, what are they called?
Dust devils.
Dust devils.
Yeah.
I remember the first time I saw it, I thought it was just like, this is
Crazy,
so
huh?
cool.
I've seen tornado-sized dust devils out in New Mexico.
Oh, wow.
So you can see them go straight
It
across
might have been in New
the
Mexico.
mesa. It just gathers like.
Mesa is like the table hill, right?
Yeah, it's
Yeah.
just like flat high up, so
Okay.
the wind just creeps across it.
No, I'm not sure about
Dust
that.
devils.
I'm not sure.
Yeah, we go sideways like this, like one wind going one way and one
Yeah,
going another
and
way.
it looks like a classic little scribble tornado.
Yeah.
Yeah.
Wily coyote type.
Yeah, definitely. They're kind of beautiful,
Yeah.
but I wouldn't want to be in one.
Those
Actually,
are fine.
I was
They
really
just roll
close
past.
to one.
I've had one hit my trailer. It's fine.
Okay.
It's just like.
Yeah, I was on the highway. It was just like where
It
Professor
goes through your
Altman.
car. It's fine. I've had it go through my car. It's fine. But clouds are different. There's a lot more wind and rain and. Yeah, a lot of rain.
There's a movie about like tornado chasers, right? Or,
Yeah, at least one. What was the one? I'm forgetting the
Storm
name of it.
Chasers?
No, that's the show. Twister.
Twister, yeah. And then they were in a tornado, right? And the truck was being spun.
Aw, thank you.
Yeah, that was scary.
That's what I wanted to do with my life, but still never seen a tornado.
Just get a really heavy truck, right? And you'll be safe.
Yeah, I
Yeah.
think so. That's pretty much how it works, for sure.
Okay. Alrighty, I'll see you all.
Thanks for the night anyway.
Yeah, absolutely. I think I take
Thank you,
decent.
Dr. Alton.
Mhm.